Right now, the phone in your pocket is keeping a record of where you are. It does it automatically every few minutes, and it sends that record to your carrier. In 2011, police used 127 days of one man's location records to place him near a string of robberies. And they got those records without a warrant. The question that reached the Supreme Court was simple and enormous. When your phone tracks you, who does that trail belong to? We have spent 2 episodes watching the court draw the line of privacy, first on a public sidewalk, then on the phone in your pocket. Each time the rule depended on something you could point to, a body, a device, an expectation you could see. But your phone broke that logic. It exposes you constantly, not because you chose to, but because that is how the network works. Over the next 12 minutes, the case that asked whether decades of old privacy rules could survive a device that follows you everywhere, and the line the court finally drew in the digital age. In 2010 and 2011, a series of armed robberies hit stores around Detroit, Michigan, electronic shops and phone stores, hit by a rotating crew. When the police arrested a suspect, he confessed and gave them names and, crucially, phone numbers of the men he said were involved. One of those numbers belonged to a man named Timothy Carpenter. To build their case, investigators did not need to follow Carpenter or watch his house. They went to his wireless carriers and asked for something most people in 2011 did not know existed: his cell site location information. Here is what that is. Every time your phone connects to a tower, to send a text, take a call, or just check for messages in the background, the network logs which tower it used. Those towers cover known areas, string the records together over days and weeks, and you do not just get a few points. You get a map of a person's movements hour by hour. The government obtained around 127 days of Carpenter's records, almost 13,000 location points, about 1,298 in all, tracing where his phone had been. The data placed him near several of the robberies when they happened. He was convicted and sentenced to 116 years in prison. And the police had gathered that 127-day map without a warrant. They had not convinced a judge that there was probable cause. They had used a federal law that let them get the records on a much weaker showing, a standard far below the one the Fourth Amendment usually demands. The reason they were allowed to do that came from a rule almost no one outside a courtroom had ever heard of. That rule is called the third-party doctrine, and to understand Carpenter, you have to understand it. In the 1970s, the Supreme Court decided a pair of cases about information people had handed to someone else. Bank records in one, the phone numbers a person dialed in another. The court's logic was that once you voluntarily give information to a third party, a bank, a phone company, you have given up your reasonable expectation of privacy in it. You took the risk that they might turn it over. Remember the principle from our last episodes. Privacy is protected when society accepts your expectation as reasonable. The third-party doctrine said that if you shared the information, that expectation was gone. The government could get it without a warrant because, in the eyes of the law, it was no longer really yours. In 1979, applied to a list of dialed phone numbers, that idea was already aggressive, but it was containable. A list of numbers is thin. It does not tell you where a person slept, who they visited, or whether they went to a clinic, a church, or a protest. Cell site records are different in kind, not just degree. You do not choose to send them. Simply by carrying a phone that is turned on, which in modern life is nearly everyone nearly always, you generate a continuous record of your location and hand it to a company. There is no door to close. There is no way to step out of the booth. To opt out of the tracking, you would have to disconnect from modern life entirely. And there is no realistic way out. You cannot hold a job, raise a family, or call for help in modern life without a phone. And the moment it is on, the tracking begins. The 1970s idea of voluntarily sharing assumed a choice. Carrying a phone is not a choice in that sense. It is the price of admission to ordinary life. So Carpenter's case forced a collision. On one side stood a 1970s rule, share it and you lose it. On the other stood a device that shares your location constantly, automatically, with no real choice involved. If the old doctrine applied, then the most detailed map of your life ever created was available to the government for the asking. In 2018, by a vote of 5-4, the Supreme Court ruled for Carpenter. Accessing his historical location records was a search under the Fourth Amendment, and to get them, the government generally needs a warrant. Chief Justice John Roberts wrote the opinion, and he was careful about how far it reached. The court did not throw out the third-party doctrine. It refused to extend it. Cell site location information, Roberts wrote, was a new kind of record. A comprehensive, detailed, effortless chronicle of a person's movements, reaching back through time in a way that no traditional surveillance ever could. Two things made it different. First, the depth. This was not a single trip or a single call. It was a near-perfect record of everywhere a person had been for months, revealing the privacies of life, family, politics, faith, health, through the simple fact of location. Second, the lack of real choice. You do not meaningfully volunteer this information. It is created automatically just by keeping a phone on. The old idea that you assume the risk of sharing did not fit a record you cannot avoid generating. So the court drew a line. When the data is rich enough to map your entire life, and you have no genuine way to avoid creating it, sharing it with a company does not strip away your privacy. The government still needs a warrant. The four dissenting justices warned that the court had opened a door it could not close. Where exactly is the line? How much data is too much? Is location special, or will the same logic eventually cover your emails, your searches, your purchases? They argued the court had traded a clear rule for a vague one, and that drawing these lines was a job for legislatures, not judges. The dissenters had a fair worry. A clear rule, even an uncomfortable one, tells the police exactly what they may do. A blurry line invites years of new cases just to find where it really falls. And until they are decided, no one is quite sure. They were not wrong that the line is blurry, but the majority had decided that a blurry line in the right place was better than a clear rule in the wrong one. Carpenter is the moment the Fourth Amendment stepped into the smartphone era. For the first time, the court said plainly that digital data can be so revealing that the old rules simply do not fit it. But notice what the decision did not do. It did not say the government can never see your data. It said that, for this kind of record, it usually needs a warrant, a judge, and probable cause. The protection is real, and it is also narrow. The court deliberately limited the ruling to these facts and left dozens of harder questions for later. And those questions are already here. Your location is only one of the trails you leave. There are records of what you search, what you buy, who you message, and what your devices sense around you. Each of those is held by a third party. Each of them, under the old doctrine, might be fair game. Carpenter cracked that doctrine open for location data. It did not resolve the rest. That is the unfinished part. Carpenter answered the question for location, but the same logic is now knocking on every other door. Your searches, your messages, the quiet sensors in the devices around you. Each new case will ask the court to decide, again, whether a record you cannot avoid creating is still yours. So the line we started drawing on a Cleveland sidewalk is still moving. Every new device asks the same question in a new form. What have you truly kept private, when modern life requires you to hand so much of yourself to someone else just to function? 3 episodes, 1 question. On a Cleveland sidewalk, the court asked how much the police could do to your body in public. With a phone seized in an arrest, it asked whether the device in your pocket was just one more thing to search. And in Carpenter, it asked whether a phone that tracks you every minute could quietly erase everything the first 2 cases had built. The answer so far is that the Constitution is still trying to keep up. The justices who wrote these rulings could not have imagined the phone in your pocket. They gave us tools: reasonable suspicion, reasonable expectation, the warrant, and left it to each new generation to decide how those tools apply to machines that did not exist when the words were written. That is the real story under all 3 cases. The line between you and the people who would watch you is not fixed. It is argued and redrawn every time the technology changes. And right now, that line runs straight through the device you are probably holding to watch this.